Imagine a chaotic protest on the streets, stones flying everywhere, and a police officer orders a young soldier to open fire on the crowd to control the riot. The soldier fires, and a protester dies. Is the soldier guilty of murder? Think about it. He pulled the trigger. A life is lost. But the law says absolutely not guilty. Why? Welcome to the ultimate legal shield under Section 14 of the Bharatiya Nyaya Sanhita, formerly known as Section 76 of the IPC. This is the absolute defense of being bound by law, wrapped in a genuine mistake of fact. But wait, what if that superior order was completely illegal? What if the officer just wanted personal revenge? Does the shield break? That is the massive trap examiners set for you in tough competitive questions. And by the end of this breakdown, you will spot that trap in less than 5 seconds flat. Let us peel back the layers of Section 14. The bare text states that nothing is an offense which is done by a person who is, or who by reason of a mistake of fact, and not by reason of a mistake of law, in good faith believes himself to be bound by law to do it. Let that sink in. Notice the absolute structural pillars here. First, you must be bound by law, or you must honestly believe you are bound by law. Second, that belief must stem from a mistake of fact, absolutely never a mistake of law. And third, it must be done in good faith. Let us take the classic court officer example that pops up constantly in multiple choice questions. A court issues an arrest warrant for a person named John Doe. The execution officer goes out, conducts a rigorous, careful inquiry, and based on excellent circumstantial evidence, mistakenly believes that another man, let us call him Smith, is actually John Doe. The officer arrests Smith. Has the officer committed the offense of wrongful confinement? No, because it was a pure mistake of fact made after due diligence, meaning it was done in good faith while executing a legal duty. But now let us flip the coin and walk straight into the deadliest zone of criminal jurisprudence, the core Latin maxim driving this entire exception: ignorantia facti excusat, ignorantia juris non excusat. Ignorance of fact excuses, but ignorance of law is absolutely no excuse. Imagine an international traveler flies into India carrying a significant amount of gold, completely unaware that the country just changed its regulatory laws overnight to ban such imports. The traveler says, "I am sorry, I had no idea this law existed." Will the court let them go? Absolutely not. This mirrors the landmark case of State of Maharashtra versus Mayor Hans George, where the Supreme Court made it crystal clear that even if you are a foreigner and it was practically impossible for you to know the newly published law, ignorance of law provides zero defense. Why? Because if the state allowed people to plead ignorance of the law, every single criminal would simply stand in the dock and say, "Oops, I did not know stealing was illegal." The entire judicial system would collapse. Now, let us circle back to our soldier example, because this is where the examiners truly separate the toppers from the rest. In the famous case of State of West Bengal versus Shew Mangal Singh, a situation arose where a subordinate officer opened fire under the direct commands of a superior officer during a highly volatile situation. The court held that the subordinate is fully protected as long as the order is ex facie lawful, meaning it conforms to the commands of the law on its surface. Pause. But what if the superior officer orders a soldier to shoot an innocent child walking on the road? Can the soldier shoot the child and claim protection under Section 14 by saying, "I am bound by law to obey my captain"? No, a million times no. An order to shoot an innocent child is patently illegal, completely void on its face. A reasonable person can see right through it. If the order is manifestly illegal, the duty to obey vanishes, the element of good faith is instantly destroyed, and the soldier will be prosecuted for murder right alongside his captain. Let us unpack what good faith actually means, because the law defines it very strictly. Good faith requires due care and attention. You cannot just close your eyes, behave recklessly, and then claim you made a mistake of fact. Let us look at a standard problem question from past papers. A police officer sees a suspect running away who matches the description of a notorious gang leader. Without calling out, without checking his profile, and without any verification, the officer opens fire and injures a bystander. Can the officer claim shelter under Section 14? No, because he failed to exert due care and attention, stripping away the element of good faith. Compare this with another classic case, Dakhi Singh versus State, where an officer was chasing a suspected thief escaping from a moving train. In the chaotic struggle and movement, the officer fired to disable the thief, but the shot accidentally killed the person. The court meticulously analyzed whether the amount of force used was proportional and whether the officer acted with due care under those specific, high-pressure circumstances. Now, you might wonder, what is the core structural difference between Section 14 and Section 17 of the Bharatiya Nyaya Sanhita? Remember how I told you that we are opening a bigger box of secrets? Section 14 deals with situations where you believe you are bound by law, meaning you have a mandatory legal obligation to act, like a soldier or a court bailiff. On the flip side, Section 17 deals with situations where you believe you are justified by law, meaning you have a legal right or permission to act, such as exercising the right of private defense or catching a murderer in the act. The exam will deliberately mix these two up in the options to throw you off balance. Just ask yourself one simple question when looking at the facts. Was the person under a command to do it, or were they choosing to step in because they felt legally justified? If it is a command, anchor your answer firmly to Section 14. If it is a justification, sail smoothly towards Section 17. So, let us tie the entire golden chain together before you tackle your next practice paper. For an accused to successfully walk out of the courtroom using Section 14, they must prove 3 things without a shadow of a doubt. 1. The mistake must be an honest misunderstanding of factual circumstances, not an ignorance of legal statutes. 2. The mistake must be highly reasonable under the given circumstances, reflecting the standard of care expected from a prudent person. And 3. The action must be executed under the genuine belief of a binding legal duty. Master these 3 elements, watch out for the trap of manifestly illegal orders, and you will never lose a single mark on general exceptions again. Finally, the concept is entirely clear and locked into your long-term memory.